If my bank account has only my name on it and I pass away, the bank will freeze the account. How will the bank know that I've passed away? Well, a couple of ways. The Social Security office may stop the monthly checks, for example, or one of my children can bring a death certificate to the bank and ask for access to the account, in which case the bank manager will very politely say, "I'm sorry, your name is not on the account, but thanks for letting us know about your mother." Account frozen. When an account is frozen, nothing can come in or out. The people who need expenses to take care of me will not be able to have access to the account. If I have pension checks or any other monthly checks coming into the bank account, that will be returned, will be bounced. And if I have set up auto pay to take care of my utilities or any car monthly payment, that will stop as well. And the account will remain frozen until the bank receives an order from the court on what to do, because the bank does not want that responsibility. Now, you may think that, oh, I only have a few $1,000s in my bank account. Do I really need to worry about it when it comes to estate planning? Well, the rule is that as long as your entire estate is greater than the threshold for what is designated as a small estate, and that threshold is not very high. For a lot of states, that threshold is $75,000. In New York, it's even lower, $50,000. So if your entire estate exceeds that threshold, then no matter how tiny or small your bank account is, probate. Another question that people ask me is, well, what if my spouse is on the account with me? The legal term for that is joint tenant with rights of survivorship. That's better. That's better than nothing, because if something happens to me, my spouse will just continue with the account, withdrawing, depositing as usual. But what if both of you are in that proverbial car accident together? Then you'll have no other names on the account. Probate. So how do we avoid our bank accounts from causing us to go into probate? There are two main ways to avoid probate. One is by titling your assets into a revocable living trust, because those assets now will not be in my personal name. So if I pass away, there's nothing for the court to supervise the transfer of titles, because the title has already been transferred out of my name. The second way to avoid probate is by using designated beneficiaries. You simply name a person to inherit your assets upon death. The first method, Revocable Living Trust, you can only do that with certain assets, such as a house, a boat, a business interests. The second method, designated beneficiaries, also can only be applied to certain assets, such as retirement accounts, life insurance. So you cannot retitle your retirement fund, for example, inside your living trust. The bank account is interesting because it allows both options. With a bank savings or checking account, you can retitle to the trust, or you can designate beneficiaries. Both methods give you full control of your asset while you're alive and bypasses probate upon death. That is the combination we want, right? Full control while we're still alive, and upon death, it does not go through the cumbersome probate process. So, which is the method to go with? I want to share the trade-offs of each of those two methods so you can make the best decision for yourself. Let's start with the Revocable LIving Trust method. In this method, you would go to the bank and you would retitle your bank account to the trust. The biggest advantage of retitling any assets into a trust is that with a trust, you can have a lot of flexibility and control in how and when you want the assets to be distributed. Example, you can specify in your trust documents that the inheritance is distributed in stages. When your child turns 30 years old, they'll get a third of their inheritance, and another third when they reach 35 years old, and so on. You can also specify incentives, that your children will only get their inheritance after they get their college degree, or put conditions. Or you can even withhold funds from your heirs if they are of minor age, or if you feel that they're just not ready to handle a lot of money. That is the biggest advantage of retitling your bank account to a trust. The money from the bank account gets transferred into the living trust and falls under all the rules and conditions of the trust documents. That is the biggest advantage. There is a disadvantage of retitling your bank account into a trust. First, some banks are just not trust savvy. They require you to jump through a lot more hoops to do anything on the account because it's not just a regular account, it's a trust-titled account. So that's one disadvantage. It's also sometimes makes it clunky for day-to-day banking. Some payroll services will not allow you to specify a trust title account to receive your direct deposits because of tax implications, potential tax implications. They don't want to deal with it. Transferring money online, as I do, I transfer money abroad, to and from my family. That gets trickier, more paperwork when you involve a trust-titled account. Let's talk about the second option, designating direct specific beneficiaries to your bank account. You can assign a single beneficiary to get the entire account, or you can assign multiple beneficiaries. With retirement funds, that feature is called designated beneficiaries, but on bank accounts, it has a different term, a different jargon. It's payable-on-death. So you simply set up a meeting with your bank manager, request a payable-on-death form, and you specify the names of your beneficiaries on the form. So that's the advantage of doing it this way. It's very easy to set up, and it does not disrupt your day-to-day banking because it's just something you add on, but it behaves and looks and smells and sounds like a totally regular banking account. So payroll processing won't have any issues with it. Online banking is just business as usual. What is the disadvantage of doing it this way? The biggest disadvantage of using payable-on-death on your business account is that upon death, the distribution of the assets is one outright lump sum payout. So the entire account is drained and the entire amount is given as a check to your beneficiaries. I don't know about you, but I have 2 young adult children, and even though I've had many money talks with them since they were young, and I consider them financially responsible young adults, I still worry that too much money too quickly can make my kids do stupid things. I'm sure you've heard of lottery winners, right? A lot of them lose their lottery winnings in a few years, and some of them are actually worse off after winning a huge sum of money in a very short period of time. So that is my biggest concern with the payable-on-death way of avoiding probate. Yes, you do avoid probate. Yes, it's easy to set up. Yes, the money does go directly to the heirs, but it could just be too much money, too quickly, and it could harm my children if they're not prepared. So what I've decided to do is to leave my current banking account as is, but add the payable-on-death feature. So I specify my children on the payable-on-death form so that if anything happens to me, the money goes to them. But I also open a new account. It's not a business account. It's not an individual account. It's a trust account. And that's actually one of the options when you open a new account. There's a box that says, is this a trust account? So I open a new trust account in the name of the trust. So this account is owned by the trust, but I am still the trustee, so I can do anything I want with this account. I still have full control over the account. And that is where I keep my rainy day fund. I would make transfers to it if my personal banking account gets beyond a certain threshold. So I try to keep the first personal banking account, say under $20,000 for day-to-day banking activities. But anything beyond that, or if I get an extra savings or income stream, I would transfer it to the trust account. So what I'm doing is taking the best of both worlds. I keep my current checking account as a personal account, so it's nimble for day-to-day activities, but I keep the balance low. And most of my funds are in the trust account. So if anything happens to me, that goes straight into the trust and gets subjected to trust document specifications. A word of caution, though, when you use payable-on-death features or any beneficiary designation feature is to review it often. Because if you have multiple beneficiaries and upon death, one of your beneficiaries has predeceased you or has become mentally incapacitated, the bank will be thrown into a loop. They wouldn't know what to do with this beneficiary's share. And you know what banks do when they are not sure what to do? Yeah, they freeze the account. They wait for the court to tell them what to do because they don't want to take the responsibility. So make sure to review your beneficiaries often to make sure they are current.